Assalamualaikum, we are from Group 9 and today we are going to discuss about MGM3143 Commercial Law for Question 2. So here is Group 90 member which is we have FARISHA NATASYA, ZUAIN ANISA, Nur SABRINA, BATRISYIA FARHANNA and SITI NURAIN. As a first presenter, let me introduce myself first. My name is ZUAIN ANISA binti Muhammad and my metric number is S66743. So in this problematic question, there is two problems, which is the first one is a purchase agreement with SAMI, which Mas Sundram Berhad had bought 10 acres of land from SAMI for 2 million ringgit, which was way below the current market value. The other factor that made SAMI sell at a lower price was that he was on the brink of being bankrupt. A factor broke about the financial crisis. Once SAMI became a financial stable, he again wants to avoid the contract and now explain that the price was unconscionably low.
Issue of SAMI case. The first one is whether the sale agreement between SAMI and the other party is enforceable under contract law. And the second is, would SAMI be able to break the contract after he is free from financial problems and realize that the agreed price is unjustifiably low? For law, we can consider on Contracts Act 1950 Section 14, which is consent is said to be free when it is not caused by coercion, undue influence, fraud, misrepresentation, or mistake. Driven by acute financial distress and the imminent threat of bankruptcy, SAMI felt compelled to accept this offer to settle his multi-business debts and stave off legal action from his creditors. Second is Contract Act 1950 Section 15. Coercion includes committing or threatening to commit any act forbidden by the penal code, or the unlawful detaining or threatening to detain any property to the prejudice of any person whatever, with the intention of causing any person to enter into an agreement. Other than that, Section 26 in Contract Act 1950, the inadequacy of the consideration was immaterial and the consent of the promissory was freely given. Therefore, the agreement was upheld. For the case related, we can refer on Pau On versus Lau Yu Long, K. Murugesu versus Nardarayan, 1980, and Pang Sui Kim versus Beh Ai Hock. Refer on Pau On versus Lau Yu Long case, which is Pau On owned the shares of a private company which owned a building that the defendants wanted to buy. The defendants were majority shareholders in a public company. The plaintiff agreed to sell their shares in the private company to defendants so that defendant could acquire the building. In return, the plaintiff would get shares in the public company. Fearing a drop in share value of the public company would result, plaintiff and defendant made another agreement that plaintiff would not sell their shares for a while. However, plaintiff realized that defendant might profit from this agreement and demanded that this second agreement be replaced with one in which plaintiff was indemnified for any fall in share value but might also benefit from any rise in share value. Fearing that not agreeing to this would delay the main contract, defendant agreed. The share value did drop, and plaintiff sought to rely on the indemnity contract.
SAMI argues that the low price of the sale was due to his financial difficulties, raising question about the validity of his consent. If he can prove that he was under pressure or compulsion because of his financial situation, it may support his claim that his consent was not freely given. However, according to the legal case Pawon vs. Lau Yu Long, a contract may still be upheld even if one party consents under duress. Additionally, a contract may not be voidable solely due to inadequate consideration or a factual error. If SAMI knowingly agreed to the sale despite being aware of the market value, his claim of unconscionability based on the low price may be weak.
Jump to the conclusion. So based on the facts and rules of law, Mas Sendirian Berhad and SAMI's purchase agreement for the 10 acres of residential land may be deemed unconscionable. Mas Sendirian Berhad should carefully evaluate the circumstances surrounding the transaction and obtain legal assistance to determine whether the agreement is enforceable. Additionally, they should be prepared to address any potential legal challenge that may be arise due to the vulnerability of one party in the contract.
The second fact was Mas Sundram Berhad entered into a lease agreement with Leong for an office building with a monthly rent of 1,500. The lease had an indefinite duration, allowing Mas Sundram Berhad to occupy the premise for as long as they wish. Leong now wants to invalidate the contract due to the indefinite duration and more attractive offer from other potential tenants.
The issue of Leong case is whether the use of "for as long as the company wish" is considered invalid in the contract because it's not clear and can Leong revoke the contract. So for the first law we choose is under section 23 of the Contract Act 1950, which state a contract is not voidable merely because it was caused by one of the parties to it being under a mistake as to a matter of fact. For this case, Leong, who is cited to have tenant after he worked hard to find reliable tenant and made a rash decision resulting in the establishment of an agreement with Mas Sundram Berhad. Next, we use Section 26B of the Contract Act 1950, which states it is a promise to compensate, wholly or in part, a person who has already voluntarily done something for the promisor or something which the promisor was legally compellable to do. The situation is, Leong did not have tenant at first and Mas Sundram Berhad was the first tenant when no one to lease the space during pandemics. However, after the pandemic ended, he was approached by attractive rental offers from other potential tenant and forget about his contract with Mas Sundram Berhad. So for the last law, we choose Section 30 of the Contract Act 1950, state that agreement the meaning of which is not certain or capable of being made certain are void. According to this case, Leong questioned the contract, claiming that the term "as long as company wish" are not clear because there is no specific time until when the company will stay. For the example case, we choose Karupan Chetty v. Swahtiam. In this case, the lessor agreed to lease the land in question to the lessee for a monthly rate of Rm35 for as long as he likes, and the court held that the said contract was void due to uncertainty. The meaning of the word "for as long as he likes" would not be ascertained.
The case involves Leong wanting to terminate a contract with Mas Sundram Berhad due to receiving a better offer, but Mas Sundram Berhad occupying the space based on permission granted by Leong for an indefinite period of the time. This raises issue with the ambiguity of the rental duration clause in the agreement, which could render the contract void according to Section 30 of the Contract Act 1950. Similarly, the Karupan Chetty vs. Swahtiam case involves confusion over the term of a lease agreement with the clause stating it will be as long as he likes. This lack of specificity in contract terms can create legal complication, as seen in Section 26B of the Contract Act of 1950, which requires reimbursement for service rendered. In Leong's case, he may have to compensate Mas Sundram Berhad for terminating the agreement without clarifying the rental duration, in accordance with the Contract Act of 1950.
The overall conclusion of this circumstance will be determined by the specifics of the contracts, negotiation, and applicable law. It is suggested that all parties concerned get legitimate direction to decide the legitimacy and enforceability of the agreement. The legitimateness and enforceability of contract in property transaction are basic for keeping up legitimate certainty and protecting the interests of all parties, included Sami's attempt to cancel a land sale deal, as well as Leong's concern about an endless duration clause in a lease agreement, underscore the complication that come with contractual arrangement. The court conclude that under Section 26 of the Contract Act of 1950, the amount of consideration is irrelevant if openly given consent exists. As a result, the agreement was maintained, demonstrating that in Malaysian law, a contract can be enforced as long as the consideration is lawfully valuable and both parties approve. This notion is critical in case where parties reach an agreement even if the price appear to be reasonable from outside perspective.